Now, the matter of Wooden versus Hillman, case number 2018-2267-DS. My name is Marc Crotteau. I'm a referee with the 37th Circuit Court. Because this matter is being heard by a referee, any party has the right to file an objection, asking the judge to review any findings or recommendations that come out of today's hearing. Anyone choosing to do that has to do it within 21 days and in accordance with Michigan court rules. Present for today's hearing by way of Zoom is Nicole Hillman. Is that correct, ma'am?
Yes.
I'll note that Mr. Wooden is not present for today's hearing, and my review of the notice sent to him for today indicates that he was given timely notice of this hearing at his last known address. Before we went on the record, Ms. Wooden, you indicated to me that you communicated with him recently, and
Yeah,
he's at work?
I sent him a message this morning. Sorry. I sent him a message this morning and reminded him it was about noon. And I said, remember, we got court today, and he said, oh, I'm at work.
Okay, so I'm going to find that Mr. Wooden had the opportunity to appear today. He had proper notice and hasn't availed himself of that opportunity, so he's waived the opportunity to be heard on today's issues. Now, we're scheduled for an evidentiary hearing on the issue of child support based on Ms. Hillman's indication at the motion hearing that she has new employment and that the parenting time schedule that the parties are exercising has changed. So there's a couple things I can do, ma'am. I could adjourn today's hearing to a new date and have you and Mr. Wooden both appear at that hearing, take testimony, and issue a new order. Or I could refer the matter to friend of the court for them to do a support review themselves. They would do their review through the mail rather than through a hearing. They'd send each of you a questionnaire, you fill it out, you turn it in. If you fill out your part and send it in, and Mr. Wooden doesn't do his part, friend of the court would be able to use access that they have to some state level income and employment databases in order to create a new child support order. I don't have access to those databases.
Okay.
For better or worse, I've got to have information from both you and Mr. Wooden in order to create a new child support order. So because you're the one here today, I'll give you the chance to decide how we go forward. If you want, I will schedule or adjourn this to a new hearing date, or if you would prefer, I will refer it to friend of the court for them to do a review. Either way, the new order will have effect from the date on which you served Mr. Wood.
I don't know. Because really, I just want to find out if there's like a way I can just get it dropped completely. So I don't know. If we did it through front of the court, do you think that I'll be able to do that? Or if we re-adjourned, would I have to like send you evidence showing what I want? Or like showing that I have legal 50% of the time?
A couple things. The first one is that it's difficult, sometimes impossible to, quote, drop, unquote, child support.
Okay.
And that's because the statute requires that we put an order together. We don't have a whole lot of choice in the matter. There must be a child support order. There are a couple things that can be done to address that. Most of it requires, though, that there not be any state support involved. So Medicaid, food stamps, etc. for the child. Is there anything like that for Abel?
Yeah, he has Medicaid under my name.
Okay. So if there ever comes a time when there's no state support for Abel, excuse me, then there's a couple options. The first one is you and Mr. Wooden could file what's called a motion to opt out of friend of the court services. And if you do that and you meet the various criteria and you show up in court and sort of waive your right to friend of the court services, then the court will enter an order opting you out. And what that would mean is, although there's still an obligation for the parties to support the child and follow the custody and parenting time orders, friend of the court wouldn't be involved. It would just be between you and Mr. Wood.
Okay.
The other possibility is that you and Mr. Wooden convince the court, me or friend of the court, but probably me, that following the Michigan Child Support formula leads to an unjust or inappropriate outcome.
Okay.
As a practical matter, what that means is I would need to have evidence showing that, for instance, there are things that aren't taken into account in the child support formula that one or both of the parents do for the child.
Hold on. Sorry.
Yeah, I get it. So if there's something that you or Mr. Wooden are doing to support the child, or that isn't taken into account in the formula, I can deviate from the formula. But I have to start with the idea that the child support formula is giving the correct child support.
Okay.
So,
Okay. Emma, please stop. Look. Here you go. Please. Sorry. Sorry.
so the question that I have to deal with then, the immediate question is, do you want me to adjourn today's hearing to another date where Mr. Wooden might be able to be here? Or do you want me to refer the matter to friend of the court for them to do a review?
I don't know.
Either way is fine with me, but the default is, I guess, adjourning the hearing and doing a hearing in front of me. So if you don't make up your mind, I guess that's what I'll end up picking.
All right. Yeah. I guess, I don't know. Because you said that if we did it through front of the court, they'll be able to like pull up and see that I've had a job. Like they'll be able to see all that information and see that I've been paying my child support and that Abel has been under my insurance this whole time and all that.
Yes. So again, what will happen is they will send you a packet of questions in the mail. You will fill them out, giving all that information.
Okay.
And send it back to them. If Mr. Wooden fills out his, then it's smooth and easy. They combine the two and come up with a new order. If he doesn't fill out his, then they can look at their state level databases and enter a new order anyway. If you don't fill out yours, you're the moving party, you're the one who wants the updated order. If you don't fill out yours, friend of the court will probably just shrug and say, if she doesn't care, we don't care.
Yeah, I'll just grab the
So just make sure you fill yours out and send it in, and if you do that part, then they can access these state level databases.
Okay. Yeah. Yeah, I guess we'll go that way. We'll try that. See if maybe we can get him to cooperate this way. Hopefully.
Fair enough. So what I will do then is find that it's appropriate to refer this matter to friend of the court for a child support review. As I've said before, the new order that comes out of this process will have effect from the date of service of the original motion, which was I can't remember exactly. Oh, there it is, back in February sometime, it looks like. So, any rate, a few months ago.
Yeah.
So the new order will snap back to that time frame. Any other questions or issues for today, ma'am?
Well, so what does that mean that the order will go back? So will that be like anything that I'm like behind on, like any of my rearages is gonna take that out?
So it might. I mean, I don't know what the new order will be, but if it's assume for the sake of argument that it says that you're supposed to end up paying less than you were paying under the current order, then from the date of service in February or March or whenever exactly it was, forward, you will have been charged that smaller amount, so if you were behind, it may very well eat up some of the arrears.
Okay.
It ends up depending on what the final order comes out to be.
Yeah.
Any other
Yeah.
questions?
No, that's it.
Okay, I will remind you that you have 21 days to file an objection if you want the judge to review decisions I have made. I'll close the record. Done. I will stop